Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty here at iExamB. In this video, today we are going to discuss about jurisprudence and how you have to study this topic from the point of view of SEBI Grade A Legal Officer examination. How से ज़्यादा I would suggest why you should study this topic. बिकॉज इस टॉपिक में से कुछ प्रीवियस ईयर पेपर्स अगर आप देखोगे तो क्वेश्चंस नहीं आए हैं एंड अगर आए हैं तो बहुत ही नेग्लिजिबल नंबर में आए हैं. सो वी विल बी सीइंग द रीजन एग्जैक्टली व्हाई वी शुड स्टडी दिस टॉपिक एंड हाउ मच we need to study this topic. Along with that, we will also be discussing some questions to have an idea that what type of questions can be asked from such kind of subjects which are having less weightage on this in this exam. So watch this video till the end as it will give you many insights for your preparation. Jurisprudence, very important topic. I will tell you why, because it talks about what law is actually. It is legal theory. It is the base of all the laws. So it helps you a lot in understanding the concepts of law and changes your perspective about law. So whenever you are solving any questions in the competitive exam also, this changes your perspective about solving the questions. ये मैं आपको जो बोल रही हूँ शायद ये कुछ लोगों को ये बात ना समझ में आए या उनको ये बात कन्विंसिंग ना लगे, but this is something which affects when you are having your changed perspective which is more towards the legal theory. Then when you are solving the questions in the examination, you are more inclined towards the best possible answer, because you know that in the MCQs, in competitive examinations, the answer which is the best, which is the most appropriate, you have to choose. Sometimes there are very similar or near options and then you get confused. So when you have such kind of perspective, which is legal perspective developed in your mind, then automatically you can interpret the laws well and you can apply the laws well. That's why this subject is very important and I will let you know कि आपको कितना time इस subject को actually देना है. So let us see one very important topic from jurisprudence I have picked for discussion today, that is schools of jurisprudence. We will be discussing the schools of jurisprudence. In short, we will understand all the schools and their ideologies. Along with that, we will see some questions as well. Schools of jurisprudence. Schools basically means what? It actually means theories. Theories होती हैं, कुछ ideology होती है, जिस आइडियोलॉजी पर एक टाइप के आइडियोलॉजी वाले लोगों को एक स्कूल में कैटेगराइज कर दिया जाता है. और स्कूल जो होती है एक्चुअली दैट इज सिंपली इट इज अ थियरी. सो देयर आर अराउंड 5 schools of jurisprudence. एनालिटिकल स्कूल, फिलोसफिकल ऑल्सो नोन एज एथिकल स्कूल, इसको नेचुरल लॉ स्कूल भी कहा जाता है. देन वी हैव हिस्टोरिकल स्कूल, then we have realist school, and then we have sociological school. So all these schools you need to understand the basic ideology and the propounders who belong to which particular school. That also you have to remember कि जैसे अगर जॉन ऑस्टिन है, commonly named person from jurisprudence, he belongs to which school, you should never have a confusion in your mind. इतना basic आपको jurisprudence में से करना ही है. I'm not saying that you go into very much depth of all the schools, but the basic ideology of the school and the people who belong to these schools, इतना भी अगर आप लोग कर लेते हैं, that is more than enough for you from the point of view of jurisprudence, from the point of view of schools. Other than this topic, there are some more topics like ownership and possession, right and duty, ये सारे concepts. So ये सारे concepts तो आप दूसरे laws में भी पढ़ते रहते हो, तो ये ज़्यादा time तो लेगा नहीं. So you can prepare this topic well like this. So talking about analytical school first, what analytical school says? It says that law is command and it focuses on the imperative aspect of law. That's why it is also known as imperative school. Law is command of sovereign statement किसने दिया है? John Austin ने. He belongs to the analytical school. They say that accept the law as it is. Don't go into the details that why, where, from where this law has come. It is as it is. Next is philosophical school, also known as ethical school. ये ethics और morals पर rely करता है. This says that law comes from morals. This says that law comes from our natural conscience, from our reason, from the right reasoning that we have in our own mind. That is also known as natural law school philosophy. So ये स्कूल में जो philosophers हैं ये इस तरीके से बात करते हैं. Grotius हो गया, Hobbes, Locke, Rousseau. They are also talking about social contract theory. You all know about law, how it has come, for what purpose it has come. So ये सारी theory आती है philosophical school में, philosophy kind of. Aristotle belongs to natural law school. Then we have historical school. Name itself suggests that law has developed by by historical developments. It has come from customs, it has come from traditions. The people belonging to the school are Savigny, Henry Mann. These people belong to the historical school. They say that law is found. Law is not made, it is found. Realist school, it talks about American realism भी कहा जाता है इसे. This school has a lot of contribution from the judges. That's why it is focusing on what? It is focusing on the judicial aspect of the development of law. Judicial activism आप लोग को पता होगा what it is. That law is made by courts. इसका best example हो सकता है tort law, administrative law. All these laws are common law principles that have developed from court laws. Developed by court, we can say, by judiciary. So the realist school says that जब कोई कोर्ट के सामने कोई केस आता है, that time law is made. From case to case basis, the law has to be made by the judges and the facts and circumstances need to be seen, and that particular instance the judge has to carve out a law. So that is what is the development of law according to realists. Justice Cardozo, he is contributing a lot to this theory. Then sociological school, it is talking about the social element. In this there is a famous theory, social engineering theory, that is talking about engineering element in law. It says that law is the tool for solving all the problems of the society. So law is made for that purpose, to solve all the problems of the society, to engineer. It is a tool for engineers, social engineers. That kind of element he has added in law according to sociological school. So these are the basic schools and their ideologies. Society का element is school में element में cover हो गया है. ये सारे schools के contributions and the people who are allied with these schools you need to remember. In this, Roscoe Pound, Ahering, these people are contributing a lot in sociological school. Now let us see the weightage of jurisprudence. It is along with interpretation of statutes. It is a small section over here. Phase 1, phase 2, both you will find it. But it is along with Latin maxims. It is along with administrative law, principles of natural justice. यहाँ पर torts and consumer protection. Torts वाला unit change हो जाता है. Latin maxims, terms, administrative law, principles of natural justice, jurisprudence and interpretation. All these combine together to form a 10% of weightage. Then why we should do these topics? I will tell you why. ये topics वो topics हैं जो negligible topics हो जाते हैं. So what happens? Students generally try to avoid these topics. They say that why we should study so much of theory when we are not even expecting a question from that. They go for these topics very well. And आपको जब कट ऑफ फेस करना होता है, what happens? अगर इस यूनिट, ये मैं पूरे यूनिट की बात कर रही हूँ फिलहाल, नॉट ओनली जूरिस्प्रूडेंस, पूरे यूनिट के लिए आपको फेस करना होता है कट ऑफ. एट दैट टाइम यू आर ऑल्सो वेरी गुड एट दीज टॉपिक्स, दे आर ऑल्सो वेरी गुड एट दीज टॉपिक्स. So when the cutoff is decided, on what basis it gets decided? On the such kind of questions that are coming from these areas on which people are not prepared enough, and the questions also come relatively easy from these subjects. So these are where you can score your marks, score the cutoff mark. ऐसा imagine करो. तो ऐसे topics को आप छोड़ो मत. Go through the important topics of these areas of these subjects at least. जैसे jurisprudence मैंने आपको बताया कि आपको इतने topics करने हैं, तो आप उतना कर लो, उतना समझ लो. ये स्कोरिंग भी है. अगर कोई क्वेश्चन नहीं आया प्रीवियस ईयर में तो ऐसा नहीं कि नेक्स्ट ईयर नहीं आ सकता. इट कैन बी द डिसाइडिंग मार्क फॉर यू. इट कैन गिव यू द डिसाइडिंग मार्क. सिमिलरली टैक्सेशन, ऐसे टाइप के जो यूनिट्स हैं, इन सबको आपको छोड़ना नहीं है, एज इट कैन एड अ लॉट इन योर स्कोर. रिमेंबर दैट. What others are doing well, you have to do well. But other than that, you have to do something more, which other people will tend to ignore because it is a competitive exam. Remember this aspect. Let us see some questions from jurisprudence. According to John Austin, the proper subject matter of the study of jurisprudence is what? Positive law, customary laws, law improperly so called. Both A and D. So these are all the terms that have been used in analytical school somewhere or the other. So they have added that. John Austin के हिसाब से कौन सा subject matter form करता है law का? The answer is positive laws. He has focused a lot on positive laws, laws that are set by political superiors, which the people have to follow mandatorily. Imperative element is added by him. Political superiors are adding some laws. So these laws are properly so called and they are actually positive laws. Properly so called. यहाँ पे ऑप्शन में क्या दिया है, लॉज इम्प्रॉपरली सो कॉल्ड, सो ये गलत ऑप्शन होगा. Which of the following is not a basic feature of the command theory given by Austin? John Austin and his theory is very, very important and questionable from jurisprudence. So his command theory is very, very famous. Which of the following element is not a basic feature of command theory given by Austin? Out of all these elements, which is not the element has been asked to you? The answer is E, improper laws. He has not discussed improper laws as a part of command theory. He has discussed and distinguished between proper and improper laws, but not as a part of the command theory. According to Austin, the basic features of command theory are what? Command, duty, sanction, sovereignty. All these are the basic features of this command theory, because he says that law is a command. Law is a command of sovereign, which automatically implies duty and sanction. Duty and sanction are implied in it. Sanction is very important element of law according to Austin, and sovereignty also he has recognized. But he has not talked about improper laws as a part of the command theory. Who introduced the concept of pure theory of law? Another very important theory. It has been introduced by whom? ये commonly asked question है, काफ़ी एग्जाम्स में अगर आप देखोगे क्वेश्चन आता है प्योर theory of law पर भी. And the answer is D, Hans Kelsen. Hans Kelsen has talked about the pure theory of law. His idea was propounded by him. He was an Austrian jurist, and in late 20th century he started his career. He said that law should be separated from all the disciplines. He focused on the pure theory of law. He said that law is not sociology, law is not economics, law is not history. Law is separate from all these disciplines. Law is something in itself, a theory in itself. This is what is his analysis of law. According to Kelsen, another question from his theory, every country there is a hierarchy of legal norms headed by what he calls as the grundnorm. Grundnorm theory, very, very important. Here grundnorm is referred to the basic norm. In this context, which is the grundnorm in India? In this context, which is the grundnorm in India? Here we have to apply Kelsen's theory and find out what is the grundnorm. Grundnorm and normative system, you need to understand, very simple it is. Kelsen has said that all norms are there. There is a normative system, and he said that law is a normative science. It is not a science. It is different from science as it is pure, but it is normative in nature. It is systematic. All laws are basically norms, and which is the grundnorm? Grundnorm is the superior one. So आपको पूछा गया है कि grundnorm इंडिया में कौन सा है? So of course the answer is constitution. It goes without saying that constitution is the rule of law, law of land for us in India. All the statutes are the norms. So this is what is the application of grundnorm theory of Kelsen in India. Last question for our discussion today. Who for the first time coined the term legal theory? Very basic question and knowledge based question. If you know this, you know this. So now after watching this video, I hope everybody remembers this, that first time the term legal theory in jurisprudence, legal theory, this term first time was coined by W. Friedman. He has introduced it in 1945 in one of his book on legal theory, and it has become very popular. That's why this question is also important and is asked generally. It is talking about the present tendency, is talking about legal theory to jurisprudence. Now we focus more on jurisprudence term, but now but the time when this was developed, this field was developed, that time legal theory was actually a very important term when Friedman had coined it. There is also a month-end sale which is going on, which I wanted to tell you all, that go and check the courses that are available at the website of iExambi, www.iexambi.com, because there is a month-end sale of flat 40% off on all the online courses. So do check it out and avail the exciting offers that are there. Don't forget to subscribe to our YouTube channel and stay updated with all such kind of content and beneficial videos. Prepare 50% faster with iExambi. Thank you.